Hey Bougie gang, what's going on, guys? I feel like we're gonna do 2 lives today, so we're gonna handle some business and then we're gonna come back and handle some other business. Okay. Nonetheless, how's everybody doing, guys? Your girl has been live all morning long, and I got to take my daughter out to lunch. My God. I think we're having curry chicken. I can't wait. Yes, I'm here. So the next live, guys. Let me wait till the music cuts out. Welcome back to Real Talk Bougie, guys. Welcome. We are so happy that you are here. We do reactions, reviews, and commentary on whatever we want to talk about on any given day. We have a lot going on. I don't know what you like. You guys are. Hey guys. Hey everybody. Okay, guys. This was number one. Let me say hi to everybody. Welcome. If you're new here, you don't have to be. You don't have to be new here. Okay, just jump right on in. Hit subscribe. Okay, hit subscribe, set your notifications, and hit the thumbs up. Okay, won't you? Now, okay, guys, we do have some business to handle, and I do have a call I want to talk to you guys about specific to Nesto and Sonia, but we're not doing that right now. So I hope anyone's too disappointed. The live that we do when I get back is going to be we got to do our members and mods. We skipped members and mods this week for some reason. I'm not sure why, what happened on Wednesday, but my bad, y'all. We will do, it'll be a open live, but it'll be members and mods. So typically we do that on Wednesdays. We didn't do that this week. I'm not sure what happened. We are getting loose and free with it. But I want to welcome all of you. Girl, the streets have been busy. So I did put up a short this morning regarding Nesto's denial. We already know all about that. I mean, you guys are super duper current and up to date on everything that's going on. Okay. This would be no different. So I did put up a short this morning, and I do want to go a little bit more in depth on the Nesto matter. And court and all of that. And I've got a call from, when's the call from? I'm posting it to Patreon, and I will post it the uncut here. I do have a few uncuts. I was working on that last night. I was going to come live last night, but I said, let me get this housekeeping done in terms of some of these calls that we've played that I have not posted yet. And I know you guys like the uncut version, and I don't have a problem doing that. It just, I have to take time to make that happen. So that's what I was doing last night. I was actually, like I said, I was going to come live, and I just said, you know what, let me handle this business. And then it was funny. Our friend, Mr. Byron, had some information about the clothing frandrew that happened with Mr. Williams. And it doesn't surprise me. And there's a call from, I think it was September 27th, if I'm not mistaken, where he and Sonia are talking, and Sonia is telling him how she plans to build up his trial wardrobe. Okay. Ma'am has so much, but yet so little to talk about. What did you miss? We just got out of the intro. Absolutely nothing. You're good. I think I didn't get an intro because I might be what do you call it? A damn notification, because we might be notificationed out. I'm not sure. But when we finish this live, I will put up the live for the Nesto live. Right now, we have some important business to talk about, because Monday we will be in court. We will be covering Sarah Boone, Suitcase Sarah. And Suitcase Sarah got some very disappointing information on today that I would like to read to you guys. Also, I know I have it loaded. This is what I'm going to do. I have 2 case files for Sarah Boone that are loaded. I'm going to, I think I made this available to members already, but I'm going to drop it to you guys. Anybody who is following along, some of this stuff is redacted, some of it is not. All of this comes from Orange County Sheriff's Department or Sheriff's Office, excuse me. They call it the OCSO, or is that OCSD? I'm girl. Don't even get me line. We're gonna find out because I'm sure it's gonna be in here. The case file information, so all of the witness statements, things like that. If you're following me on Patreon, you know that I have posted lots of audio in the last few days regarding Stefan Starnes. That's continuing. There's court next week on that too. He's also waived a speedy trial. So sir is, I don't know what they're doing over there, but I've got a document. Some of it's redacted, some full information is there, witness statements, all of these things. I don't even want to scroll it. Let's see. Is this is this the Sarah Boone one? Hold on a second. This might be more. Okay, this is a different one. Okay, this is a different one. You guys will be interested in this one too. I got so much information for you guys, and I've just finally cleared the way to really get it organized and just dropping it in Patreon. And then I found a source where I can drop you guys a link, and it's secure, but it's not behind a paywall. So when I want to drop you guys something, not to a, you guys follow me. Anyway, any of you guys who have tested it, I did drop a couple of links this week. You guys have used it. It hasn't crashed, all of those things. So that was good. But let's get into this really quick. You guys know that Sarah Boone is on trial for second-degree murder of George Torres. We all know this, right? If you don't, now you do. Sarah Boone is a lady out of Florida who I dropped a video yesterday. There's a link up top. Get into it because we'll be talking about it next week. Sis offed her boyfriend. I mean, that's basically what it is. She's second degree. She's up for second degree murder, and it's a very serious case. She's been in jail now for over 4 years, 7 months, and a matter of days. She recently got a lawyer by the name of James Owens, and James is a little fukaka, a lot of fugazi, and so is Sarah. But it wasn't a lot of time for her to fall out with this lawyer. So he decided, if you click the link above, you don't have to do it now, but I encourage you to watch it. It was very good. It's 2 hours, but it is her police interrogation video where she dropped all of her tea and got very upset with the detectives, okay? For no good damn reason other than the fact sis fucked up. It's like, sis, you fucked up, and that's not everybody's fault to get you. It's not their problem or place to get you unfucked, okay? That was your doing. So sis is very much giving angry and upset. Let me get this back to where, okay. Sis is very much giving angry, upset, all of the things. And her lawyer decided to file a motion to suppress defendant statements at OCSO, which is the Orange County Sheriff's Office, on defendant's amended motion to suppress defendant statements at OCSO Judge Cranick, they're funny. They're tired and they're being very much giving funny. So James Owens, let me give you a little backstory. He filed a motion to suppress, and then he filed an amended motion to suppress, and then he filed a second amended motion to suppress. Okay. So this is Judge Cranick's order on the defendant's motion to suppress defendant statements at OCSO, on defendant's amended motion to suppress defendant's statements at OCSO, and on defendant's second amended motion to suppress defendant's statements at OCSO. It's the snark for me. I love it. Okay. And I mean, it's valid because he filed one, he filed another one, and then he filed another one. So at the end of the day, It's appropriate for him to say it like that. He did not have to, but addressing all matters present, he did what he felt he needed to do. Judge Kranick said, since I got to work on a holiday, which was yesterday, Judge Kranick said, I'm I'm giving zero fucks and I'm typing this out because we know Judge Kranick writes a good order. Okay. Let's get into it. Okay. All right. The cause came before the court on October 2nd, 2024. The defendant's motion to suppress statements on the statement's motion to strike defendant's motion to suppress and the state's response to the defendant's motion to suppress statements e-filed on 9/27/24. On the defendant's motion to suppress defendant statements at OCSO e-filed 9/30, and on defendant's second amended motion statements at OCSO e-filed 10/2. It's been crazy. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the second amended motion, having reviewed the court file, having considered the testimony and the evidence offered by the parties, having considered the arguments offered by counsel for the state, having considered the arguments offered by counsel for the defendant, finds as follows. Whew. The defendant, Sarah Boone, is charged by the way of an information filed 3/23/2020 with a single count of second-degree murder. On February 24th, 2024, the defendant called 911 after finding her boyfriend, George Torres, deceased. Deputy Kayla Rodriguez arrived February 24th, 2020, spoke to defendant. Also see State's Exhibit 1. You can click on my link that's pinned above. It'll take you right to her complete interrogation. And I definitely suggest watching it. We had a good time watching it yesterday, the comments and everything. It was a premiere. Detective Cupsell, a homicide detective with the Orange County Sheriff's Office, with 6 years experience as a homicide detective and law enforcement officer since 2013, was the lead investigator of George Torres's death on February 24th, 2020. Detective Cupsell arrived at the scene within 30 minutes to 1 hour of OCSO's deputies arriving, was briefed and performed a walkthrough of the apartment after a search warrant was drafted. Detective Cupsell then made contact with defendant outside the apartment for a few minutes and explained procedures of the search warrant. The search warrant was executed with CSI. Defendant's cell phone was collected after CSI documented the scene. Detective Cupsell wanted to go through defendant's cell phone to corroborate defendant's story. Defendant signed a consent prior to the February 24th, 2020 interviews addressed below. See also Defendant's Exhibit 1. Detective Cupsell did not look at defendant's cell phone, including any videos prior to the interview addressed below, as digital forensics did not arrive until approximately 7 p.m. Detective Cupsell then made contact with the defendant's ex-husband, Brian Boone. Thereafter, Detectives Cupsell and Lowen had an interview with the defendant in Detective Cupsell's unmarked Nissan Pathfinder at approximately 5 p.m. See below State's Exhibit. Detective Cupsell explained that she wanted to have a conversation with the defendant after walking the apartment. Detective Cupsell testified that she would not have interviewed the defendant outside of the unmarked car, had no memory of using the words routine, and that everything was explained on the record. The word routine is not used by Detective Cupsell in any recording. See State's Exhibit 1. Detective Cupsell explained the purpose of the interview, including defendant's prior conversation with Deputy Kayla Rodriguez and Detective Cupsell, and Detective Cupsell's desire to get a further understanding of what happened last night and ask the defendant more detailed questions. See Exhibit 1. Thereafter, Detective Cupsel began reading Miranda as follows. I'm going to read you your rights, but it's just because that's how we do things. Okay. So you have the right to remain silent. Okay. Do you understand that? Defendant, yes. Detective Cupsel, anything you say may be used against you in a court. Have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one will be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? No. Do you understand what I just read to you? Yes. Thereafter, Detective Cupsel, my bad. Thereafter, Detective Cupsel interviews defendant again after the initial digital recorder's memory was full. CID. The second separate recording was initiated. Detective Cupsel confirmed with defendant that no additional communications occurred prior to the second separate recording, and Detective Cupsel inquired of defendant prior to asking any other questions. Do you understand that you don't have to speak with me if you don't want to? Correct? To which defendant responded, yes. After including the interviews, After concluding the interviews, but before leaving, Detective Cupsel had a conversation with defendant had about coming to OCSO the next day to address the pending autopsy, and that Detective Cupsel would have more questions. Detective Cupsel did not recall speaking about the defendant's cell phone, but had defendant asked about getting her cell phone back. Detective Cupsel would not have given a specific time frame for returning the defendant's cell phone. Detective Cupsel had no memory of receiving a call from the defendant on the evening of February 24th, 2020. Defendant's testimony largely agreed with Detective Cupsel's testimony, including the timeline of calling 911, speaking to Deputy Kayla Rodriguez, and speaking with Detective Cupsel. As to the February 24th, 2020 interview, defendant confirmed that okay, there's a footnote. I missed where the footnote was. During the second separate recording, defendant used higher tier words, including compus mentis. I think we talked about that yesterday. She said something. I was like, is she speaking Latin at us? Like weird. Anyway, so he did. Judge Kranick made a note of that. Detective Cupsel explained that general questions would be asked. Defendant confirmed that she stayed on the scene 10 plus hours while the investigation was performed. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. in the next day. Defendant's own testimony was that she was under the influence of alcohol from the night before at approximately 1 p.m. the next day. However, there was nothing evidencing defendant being intoxicated or under the influence of alcohol when clearly speaking and interacting with Deputy Kayla Rodriguez. Defendant's statement of making a call to Detective Cupsel between 9:30 and 10 p.m. on February 24th, 2020 from her ex-husband's phone does not line up with defendant's own timeline of staying at the scene 10 hours, which began approximately at 1 p.m. and the court finds this statement lacks credibility. Ooh, ooh, is he saying that that was maybe a lie? It lacks credibility. Comment down below, guys. He said that it sounds like it doesn't line up. He's saying it doesn't line up, and the court finds this statement lacks credibility. I would have thought that if the detective got a call, they would have at least documented that somewhere and would have added that to the notes at some point. So maybe this weekend, or hopefully this weekend, we'll have time to review some of these notes and statements and review and see What, if anything, we can see about the detective notes and what they may have captured as to, certain things that Judge Kranick is Shade King. Okay. Defendant claimed that before they left the scene, Detective Cupsell and Lowen would return defendant's cell phone to the apartment. On February 25th, 2024, defendant claims that defendant and Detective Cupsell had a discussion regarding the picking up of the defendant's cell phone, specifically that due to Detective Cupsell's pregnancy, defendant would need to come down to OCSO to pick up the phone. Defendant's sole reason for traveling to OCSO was to pick up her phone. Footnote 3, let's see. Approximately 1 hour and 27 minutes into February 27, 2020, the defendant returns to her list of prepared written questions and specifically asks, "Am I getting my phone back?" See Exhibit 1. This prepared written question would not be asked if one was told to come pick up the phone. The prepared. Okay, that makes sense. Why would you ask if you're getting your phone back if you were told to come to pick up your phone? Okay, great point. Okay. Um the court finds the defendant's statement regarding picking up the cell phone also lacks credibility. Ew. Okay. On February 25th, 2020, after Detective Cupsell reviewed some of the extractions of the defendant's cell phone by digital forensics and attended the autopsy, Detective Cupsell requested the defendant come to OCSO's office, OSCO's office. Detective Cupsell did not want to approach the defendant in front of her child at her ex-husband's home. Defendant's worry and concern about her son was addressed with Deputy Kayla Rodriguez, also the state's exhibit. I mean, it's bad enough that the child is dealing with a non-functional drunk as a mother, and according to the father, an unreliable mother who sometimes doesn't pick up the kid on time, all of the things. Very sad for this young boy, who was in third grade at the time. So it was, it was a decent thing to do. My thing is, if you're going to do that for one, do that for everybody, because a lot of people do get arrested in front of their kids. But at the end of the day, that's sometimes out of control. But that was very nice. That was nice. Look at Sarah getting some extra privileges, right? The state and defense agree that on February 25th, 2020 interview was custodial. Okay. What is a custodial interview? So it was a custodial that she was, I custodial meet, I would, it's custody, right? So let's say custodial interview. Let me just look that up so we can get the police terminology. A custodial interview is a questioning of a person in custody. Sarah may not have known she was in custody, but the state, as well as the law enforcement, agree that it was a custody situation. A custodial interview is a questioning of a person who is in custody, where our requirements are to be informed of their constitutional rights, which she was Mirandized. And in United States, a custodial interview is also known as a custodial interrogation. Okay. She was read her Miranda rights on numerous occasions because at the time, I think they felt that they were questioning the crime scene. They were not sure of the happenings and going on, and they made it very clear to read her rights. I mean, I felt like I heard them at least 3 or 4 times. Anyway, okay, let's keep going. Um, the state and the defense agree that February 25th, 2020 interview was custodial. The pith of defendant's argument is contained in this exchange during the beginning of the February 25th, 2020 interview. Detective Cupsell, just let us know if at any time you need water, okay? I'm going to have you sit in the green chair. Appreciate you coming in. Um okay, we read that footnote already. Defendant, yes, ma'am. I want to ask about these when you have a moment, referring to her prepared written questions. Sure. So obviously he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it. And there's another footnote, just like we did yesterday. Let's read the footnote real quick. The court notes that this statement is an inaccurate statement of law, right versus state. This is something I have to do when giving Miranda warnings. This is an accurate statement of the law, as the law enforcement officers are required to administer Miranda warnings prior to custodial interviews. Just so you know, if anyone ever happens to be talking to a law enforcement officer and they give you your Miranda rights, you may technically be in custody. So this is something interesting to note. At least in Florida, which I would imagine anywhere. If you're talking to a law enforcement officer and they give you your rights, you very well may be in a custodial interview or custodial interrogation situation. Okay. Um, Normal protocol, and that is what Sarah Boone said. Detective Cupsell said, just like we did yesterday. Remember, I read you your rights? Yeah. Detective Cupsell, yeah. It's the exact same thing. But since I'm asking you follow up questions, I need to read them to you. Okay. Sure. All right. So you have the right to remain silent. Anything you say may be used against you in a court, in court. You have the right to talk to a lawyer before or during questioning without charge. If you cannot afford a lawyer and want one, one may be provided to you before questioning without charge. Has anyone threatened or promised you anything to get you to talk to me? Defendant says no. Detective Cupsell says, and do you understand what I just read to you? Defendant says yes. Um, so number one, so that's so C states exhibit one. So this is whether the Miranda warning was sufficient on, okay, so the Fifth Amendment of the United States, Article 1, Section 9 of the Florida Constitution both provide the right against self-incrimination. The self-incrimination clause of Article I, Section 9, Florida Constitution requires that prior to a custodial interrogation in Florida, suspects must be told that they have a right to remain silent, that anything they say will be used against them in a court of law, and they have the right to a lawyer's help, and that if they cannot pay for a lawyer, one will be appointed to them. That's Taylor versus State. Both Florida, both the Florida Supreme Court and the United States Supreme Court stress that there is not a telesemic tel, telesemic incantation required. Hold on a second. Telesamic. Let's look that up. So an incantation would be kind of like some sort of words of a spell or something. Telesam. I'm sorry. I cannot move forward without looking this up. Talis Talismanus incantation. Okay. Okay, maybe I need to type. Okay, what is that? Okay, here we go. A talismanic incantation is a tactic used by prosecutors to get around the confrontation clause. It involves using an incantation to convince the jury that testimony about the others said is truthful or helpful to the prosecution. The incantation is meant to get past the judge. So basically, there's no trickery involved. That's the way I'm interpreting that. Both Florida Supreme Court and United States Supreme Court have stressed that there is no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed, Miller versus State. The court does not examine a Miranda warning as if construing a will or defining a term as an easement, Duckworth versus Egan. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. Quoting California versus Prysock, the crucial test for determining whether police gave proper warning is whether the words in the context used, considering the age, background, and intelligence of the individual being interrogated, impart a clear, understandable warning of all of his rights. And that's Coyote versus United States. Miranda warning provided by law enforcement to defendant at the beginning of February 25th, 2020 interview is sufficient under both federal law, quoting Miranda versus Arizona, and federal law. Okay. There was a footnote. I missed it. Okay. So in Q, there's a footnote. In 1966, the United States Supreme Court issued its opinion on Miranda and established 4 warnings that are required prior to questioning a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Specifically, a suspect must be warned prior to any questioning that he has the right to remain silent. That's number 1. Number 2, that anything he says can and may be used against them in a court of law. 3, that he has the right to the presence of an attorney, and that if they cannot afford one will be appointed to him. That's the main 4 things that must be conveyed. The Miranda warning given to the defendant in the instant case is identical to the exemplary Miranda warning identified in Owens Supra. Okay. Judge Cranick breaks it down. Okay. If you want to talk about somebody breaking something down, that's Judge Cranick. Okay. Okay, let's keep going. This is so interesting. As such, the Miranda warning given to the defendant in the instant case was sufficient. So we already know where this is going, right? Dun dun dun. Okay. Whether the defendant's statements on February 25th were coerced. To establish that a statement is involuntary, there must be a finding of coercive police conduct, Baker versus State. Generally, to determine whether a confession is involuntary or coerced, a court must examine the totality of the circumstances surrounding it, Martin versus State. When the voluntariness, I love that they put this when the voluntariness of a confession is in dispute, it is the state's burden to prove the voluntariness by a preponderance of the evidence. So basically, there is some like a test, if you will, to kind of determine, does this person seem to be coerced, distressed, not willing to give up this information freely, right? There is no misrepresentation of the law regarding any defense, Johnson versus State. No quid pro quo, like I'll do this, you do that. No directly or specifically made promises. No overt act or threat of force against the defendant was proved or claimed. I even recall her say no to the question that Detective Cups asked her. No fear of material or physical harm, quoting Denmark versus State. No hope of material reward. No indication that the defendant was a newcomer to the law based on the 2 times Miranda warnings were provided between February 24th and February 25th. So the Miranda in question was preceded by two other Mirandas, right? Okay. State versus Watson. No indication that the defendant was mentally deficient, especially considering the verbiage she used. Okay. Compass mentum or whatever she said. No threats, delusions, deceptions, or promises. Girl, he's giving so much law, it's ridiculous. And defendant was offered water and breaks. Happy Friday, Nina. Good afternoon, everybody. We are in the middle of reading the order, okay? There was no false statements made by law enforcement in order to coerce the defendant to go to OCSO's office. She actually drove there on her own, of her own free will. Under the totality of the circumstances, defendant's statements on February 25th, 2020 were not coerced. Whether the defendant's statements on February 25th were voluntarily made. The statement is not compelled within the meaning of the state or federal law if an individual voluntarily, knowingly, and intelligently. Oh my God, he's using Sarah's words. Okay. Do you guys remember the letter that Sarah wrote? I want to say it was like her 58-page letter when she said voluntarily, knowingly, and intelligently. Judge Cranick is funny. Do you guys, any of you guys remember her those words, that word ensemble she put together? Girl, she said compass mentis. Okay. Meanwhile, now she's hungover. Okay. All right. The statement is not compelled within the meaning of the state and federal law if an individual voluntarily, knowingly, and intelligently waives his constitutional privilege. See Miranda versus Arizona. The state must prove by a preponderance of evidence that the defendant's Miranda rights were waived. Okay. It doesn't necessarily have to be voluntary. They have to just show that it's been waived. Barger versus state. To constitute a voluntary waiver, the state must show that the waiver was the result of free choice on the part of the defendant and not the product of intimidation, coercion, or deception. Two, the waiver was made with the full awareness of the nature of the right being abandoned and that the consequences of the abandonment. Only if the totality of the circumstances surrounding the interrogation reveal both a uncoerced choice and the requisite level of comprehension may a court properly conclude that Miranda rights have been waived. Factors relevant to consider include the manner in which the Miranda rights were administered, including any cajoling or trickery. Miranda, Brewer versus State, the suspect's age. So number one, the manner that the Miranda rights were administered, okay, including any cajoling or trickery. Two, the suspect's age, experience, and background and intelligence. So you want to read the room. The officer needs to, are you talking to a 16-year-old or a 76-year-old? Are you talking to somebody with little to no understanding? Is someone, is someone impaired? Is somebody operating? Is someone in the middle of a heart attack? Does someone have some intellectual deficit? Like anything, right? The fact that the questioning took place in the station house, see Drake versus State. And four, the fact that the interrogators did not secure a written waiver of the Miranda rights at the outset, which I think she'd already had her Mirandas read twice, right? The Miranda rights were administered in a normal tone and cadence. There was no rush or urgent speech. See Chafin versus State. There was no delay in the administrations of the defendant's Miranda rights. The recorded February 25th, 2020 interview reflects the defendant's understood and acknowledged that she understood her rights. See State's Exhibit 1. Defendant acknowledged that she understood her rights. See, evidence supported conclusion that the defendant voluntarily waived right to remain silent and obtained counsel when officer read defendant his rights and asked defendant whether he understood each of the rights, to which the defendant responded affirmatively. Court reincorporates the findings in U and V herein, which further show no cajoling or trickery. The defendant is 42 years old at the time she made the statements and appears to be of normal intelligence. Also see also footnote 2 above, Compass Mentis, right? Okay. Shouts out to Compass Mentis. He's not giving Sarah any leeway. She is, hold on a sec, Compass Mentis. Sis is a mess, okay? This is someone who literally shoots herself in the foot time and time again. Compass Mentis is Latin for having control and mastery of one's mind. She says that's her favorite. If you watch the interrogation, she says that that's her favorite phrase. Okay. The term is used to describe individuals who are sound mind and those who are mentally competent, capable, and managing their own affairs, those who have use of and control over their mental faculties. Okay. She used Compass Mentis in her interrogation. Okay. Period. On February 25th, 2020, interview did take place at OCSO's office, and no written waiver was secured. Under the totality of the circumstances, defendant's statements on February 25th were made with a voluntary, knowing, and intelligent waiver, and this waiver was the result of free choice on the part of the defendant and was not a product of intimidation, coercion, or deception. And the waiver was made with full awareness of the nature of the right being abandoned. Orders and adjudes as follows. The motion, the amended motion, and the second amended motion are hereby denied. Done and ordered. He said done and ordered in chambers at Orlando, Orange County, Florida. February is when it took place. Florida, this third day of October 2024. Okay. And all copies have been forwarded. The state got their copies. Sarah Boone got her copies to all attorneys, esquires, and Anita Barrios, judicial assistant to Judge Michael S. Kranick. Judge Kranick is like my new favorite judge. He's so good. He's so good. He's so good. But she filmed it because, girl, this woman is stupid and should have said, look, we played a stupid game. I fell asleep drunk. And after leaving him in the suitcase, yeah, like just she was trying so hard to not make it her fault. Look, at the end of the day, it's her fault. Because I'm just thinking, if that was my brother, if that was anybody that I love, my son, which I don't have a son, but if I had a son, I do have a brother. I'm sorry. Like, accidents happen. She was so bold. She was so bold. It took away any type of consideration that this just wasn't on some fuckery and some fuck shit to me. Okay. There's no way to get around her behavior. Yes, the man had just died, but she was very strange. She was giving very much busted. She was giving very much worried about the wrong things, right? And um she could have had a manslaughter. I think there was no way around some charges for this case, but she could have maybe had a manslaughter and maybe it would have been a little bit different. But the fact of her behavior, her trying to control something that was far beyond out of her control at that moment was her own undoing. Because it's quite possible, had she shut up, gave the police the information that they needed to handle George with dignity, and wasn't acting so fucking crazy, and maybe had a lawyer, it's quite possible they would have charged her with manslaughter. I don't think there's any way around the stupidity of the actions of that night, but I don't know that they would have given her second degree murder. Also, the video is alarming, and the video is what gave her second degree because it speaks of a depraved mind, right? I think we read the law from Florida regarding second degree murder, and it's like check, 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 check. Thank you so much, Lovejoy. I appreciate that. You guys, I love you guys so much. Thank you. Thank you for supporting, sis. There was no ways around this situation. She was gonna catch a charge. Could it have been manslaughter? Could it have been like reckless something or other? I just think the video, number one, that's second degree right there. That sealed the second degree. Had the videos not come into play, that might have been a different situation. And maybe people could have been like, I don't know, you know what I mean? We see this happen. People who like to play with their necks, okay? People who like to play with their hands while they're having sex around people's necks. We've seen that happen, right? Where people have died of some sort of asphyxiation due to some sort of sex play games that they like to do. Um, which we hadn't seen that, of course, in this case. This case on my screen, these people love to talk about some neck play, okay? These people on the screen, they love talking about some neck. That's when you might have something that's kind of like a reckless type of behavior, manslaughter, things like that. Sarah was not going to bypass the law, playing with George, playing with someone else's son in that way. She gonna have to, she on Monday, baby, that jury is being selected and they're going to hear this case, and we don't know what's going to happen, but Sarah is her own worst enemy. If own worst enemy was a person, that's Sarah Boone. Sarah Boone brings all of that, and I can't wait. If you have not seen the interrogation that was the matter of this motion, this order that we just read, click the link above when we're done with this live. Watch that. I'll be back a little bit later. My daughter is out of school today and I'm taking her for a good lunch outside. But I had to come see Bougie Gang. Okay. I said, let me, and then we're gonna, and then when I come back, I got a treat for you guys. Okay. I promise. I have a whole, we're gonna do a whole Nesto, Sonya. We're gonna get it back. We're gonna handle that business. Happy birthday, Mushagal, to our Libras on a Friday. Okay. We will sing happy birthday in the next live. Okay. When we come back, we will do our birthday. I feel like because it's Friday, we probably should just do members and mods tomorrow morning. We'll do members and mods first thing tomorrow morning because I want to give ample notice. And then I'm going to drop some memberships. I will drop some memberships in our next live. If you are not a member, you don't have access to what's going on in that member thing. Hey, Nicholas. Oh, you're welcome, hun. I will drop some memberships when we get into our next live. Okay. And tomorrow morning, just forewarning, we will do members and mods because we skipped it this week, and my bad, y'all. Okay. We have done numerous member lives though. If you're a new member, get into the member playlist. There's a lot of content in there for you. There's a lot. There's a lot. I could probably tell you guys right now. There's got to be at least 100 videos in there. Okay? And it's not previously public, now private. I'm talking about specifically members. Okay? Get your money's worth. Okay? Go watch those videos. Okay? I think that's it. I think that's it. That's all. This was a awesome read. I love reading these documents for a couple of reasons. Number one, Judge Kranick is my new favorite judge. Just number one. Number two, I love the fact that sometimes getting into these cases, you learn so much. I'm not a lawyer. I'm sure a lot of you are not attorneys in this chat. I know we do have some attorneys in our chat, and I thank you for bringing that energy here. Um, it's so interesting reading these documents and hearing and learning. Okay. We don't know it all. We can read, we know how to look stuff up. It's so interesting. I'm fascinated. I love it, love it, love it. So, anyway, guys, you guys are amazing. This was so much fun. Where am I? I don't know. It's the member or the mod for me. I love it. Oh, you guys are so sweet. Okay. All right, guys, let me go handle this day. Let me go show Boo Boo a good time. Take her out a little bit, get her some air. Ma'am has been home. She was home yesterday. And let me take her out for a nice mother-daughter outing. Go spend some cash on my baby. And when I come back, we gonna handle that Nesto Sonya business. I got a little treat for y'all. Okay. All right. You guys take care. Make sure to hit the like button for me. Share this out. Go ahead. Check out the interrogation above. You guys, it's gonna make so much more sense now if you've never seen it. When you watch it, you're going to think about this document you just listened to me read. Okay. It's going to come alive. Okay. I'll see you guys later.